sistema contra incendio como extintores, detectores de humo e hidrantes, así como botiquín de primeros auxilios. Se cuenta con 2 salidas de emergencia, el acceso principal es una y en la zona posterior se encuentra la otra. Identifique la ruta de evacuación, zonas de menor riesgo y punto de reunión. Mantenga despejados los pasillos, escaleras y salidas de emergencia del recinto. En caso de activarse la alerta sísmica, conserve la calma, permanezca en su lugar y siga las instrucciones del personal. En caso de incendio, mantenga la calma y evacúe el recinto siguiendo las instrucciones. Si requiere atención especial, indíquelo al personal del staff del evento. En caso de evacuación, diríjase al punto de reunión de manera ordenada y en silencio siguiendo la ruta de evacuación señalizada. Gracias.
Muy bien, buenos días a todas y todos. Para mí es un privilegio dar la bienvenida al Instituto de Investigaciones Jurídicas, al profesor Martín Borowski y al doctor Arnulfo Mateos Durán. Estamos muy contentos de recibirles en el Instituto, en el Observatorio del Sistema Interamericano de Derechos Humanos. Y bueno, pues damos la bienvenida a quienes están acá en el Aula Centenario, a quienes se conectan a través de Zoom y también quienes nos están siguiendo en las redes sociales del Instituto. Bueno, vamos a iniciar con la conferencia del doctor Borowski. Me voy a permitir leer una breve síntesis curricular y después le daré el uso de la voz. Él va a abordar el tema del control limitado en la jurisdicción internacional a propósito del caso Axel Springer contra Alemania. El profesor Borowski es profesor de Derecho Público, Teoría Constitucional y Filosofía del Derecho en la Facultad de Derecho de la Universidad de Heidelberg. Es miembro del comité directivo de la sección alemana de la Asociación Internacional de Filosofía Social y del Derecho. Fue vicepresidente de la sección británica de la Asociación Internacional de Filosofía Social y del Derecho y ha sido docente en diversas universidades como en Reino Unido, en la Universidad de Westminster, en Londres. Y bueno, pues ha sido miembro de distintas asociaciones académicas. Dentro de su trayectoria profesional, fue asistente principal en la cátedra del profesor Robert Alexi. Dr. Borowski, we are very happy to have here the opportunity to hear you. So now we are going to listen with attention your conference.
Well, thank you very much. Is it working? Yeah?
Yeah, it's working.
Thank you very much, actually, for inviting me. It's always good to be back at UNAM. And thank you very much for the kind introduction, maybe too kind. I'm going to talk today about a case and trying to illustrate a more general point with the analysis of that case. The main case of my presentation is Axel Springer and Germany from 2012, a case that was decided by the European Court of Human Rights in Strasbourg, in some sense the counterpart of the court in San Jose, here in the Americas. Here in this case, freedom of expression by the press, Article 10 ECHR, competes with the right to protection of private life, according to Article 8 ECHR. It is a case of Drittwirkung or horizontal effect of constitutional and convention rights. Germany's courts sanctioned the applicant, the public limited company Axel Springer, press company, for publishing 2 articles in their newspaper Bild that revealed the circumstances, first, in which an actor was arrested at the Munich Oktoberfest in the possession of a small amount of cocaine in July 2004. And second, 9 months later, the fact that the actor confessed in court and received a fine. Now, despite what we in Europe call the margin of appreciation, a majority of 12 judges of the Grand Chamber regarded the sanctions for the articles not justified and found a violation of this convention right by Germany. A dissenting opinion supported by five judges 12 plus 5, 17 judges overall. Dissenting opinion, 5 judges disagreed with the majority to the effect that the decisions of the German courts met the relevant standard of review. This is to say that, according to the dissenting opinion, the Grand Chamber was supposed to refrain from holding that there was a violation of Article 10. The facts of the case are as follows. An actor called X in the judgment played the part of the police superintendent, Balko, in around 100 episodes of a television series that was broadcasted by the German branch of the commercial channel RTL from 1998 to 2005. With an average audience rating of just below 20%, the series proved to be quite popular. In 2003, the influential newspaper Bild happened to receive the information that X, the actor, had been convicted of the possession of 4 grams of cocaine, found at his home, and that he received a suspended prison sentence of 5 months, had to pay 5,000 euros. Owing to warnings from X, the newspaper Bild initially refrained from publishing this information. At the end of September 2004, X came out of the toilet next to the Käfer tent in the Oktoberfest in Munich and tapped his nose, which was regarded to be a suspicious movement by plainclothes police officers present at the scene. He was searched and a small envelope containing circa 0.2 grams, little amount, of cocaine was found in his possession. X was immediately arrested for possession of illegal drugs. What then happened with an eye to the prosecution authority remained contested. Did they give that information to the press? At the end of the day, the Grand Chamber relied, however, on a sworn statement of a journalist from the applicant, Bild, which was not contested by the German government, that the information was received actually from the Munich prosecution authority prior to the publication of the first article. This first article in Bild in September 2004 revealed the fact that X was caught in possession of cocaine at the mentioned scene, revealing his real name and the name of the role he played, referring to the prosecution authority and a legal expert that made a prediction of the punishment awaiting X, referring also to the earlier conviction. Photos accompanied the article, which were not, however, the subject of legal proceedings in higher instances later. On the day the first article was published in Bild, other news outlets reported the story too, in part referring to the Bild article. The prosecution authority, the Grand Chamber assumes again, confirmed the arrest in a statement mentioning the earlier conviction. In July 2005, a second article, again accompanied by a photo, was published in Bild, in which the confession of X was reported along with his fine of 18,000 euros, nearly 20,000 euros. Now, X brought legal proceedings against the publication of both articles on the ground that his right to personal life had been violated, according to some sections of German private law. He sought and gained an injunction against the publication of the first article before the Landgericht Hamburg, Regional Court, Hamburg. In the main proceedings, the Landgericht held that X's personality rights were violated by the first article and ordered a penalty of 5,000 euros. This was justified by means of a rather comprehensive and detailed weighing of relevant factors in proportionality analysis. The Grand Chamber judgment gives a detailed and lengthy report of this justification in 10 marginal numbers over 3 pages in the judgment. Later, the Landgericht judged on the second article along the lines of its decision on the first article. Nothing new here. Now, the Oberlandesgericht Hamburg, Court of Appeal, basically upheld the judgment of the Landgericht, significantly reducing the amount of penalty to 1,000 euros. Far less. It referred to the factors for weighing the interest in such cases established by the case law of the Bundesgerichtshof, Federal Court of Justice, this is the next court. There was some disagreement with the Landgericht whether there was a public interest in excess person. It's an actor, after all, playing a police superintendent. It's not a political figure. While the Landgericht answered this in the negative, no interest in excess person. The Oberlandesgericht went somewhat into a positive direction. It did not, however, regard this as decisive. The reason for significantly reducing the penalty was rather the trust established by the statement of the Munich prosecution authority, in the light of which there was only minor negligence on the part of Springer and his employees. So they just reported what the authorities had told them. So they relied on the authorities in publishing that. This made this less of a problem, the ideas. The second article was evaluated along the same lines. Okay, these were the two first decisions. The Bundesgerichtshof, Federal Court of Justice, refused in both cases to leave appeal on points of law, Revisionszulassung, for that, well, there was neither a question of fundamental importance nor an issue with the uniformity of the case law. And these two reasons are the statutory reasons relevant for such leave to appeal on points of law. They saw no indication that the relevant criteria for balancing the two rights at stake had been disregarded to a relevant extent, considered against the backdrop of its own case law. Finally, the Bundesverfassungsgericht, German Federal Constitutional Court, a distinct court in the German court system, ruled by means of a Kammerbeschluss, decision by a free-judge panel, free judges only, that there was no violation of the constitutional right provided for in the German constitution. And as is actually the rule rather than the exception in such a Kammerbeschluss, it refrained from giving explicit substantive reasons to justify its conclusion. It's just too many decisions. They just say no and no reasons. Springer, the applicant, filed an individual complaint according to Article 34 of the European Convention of Human Rights to the Strasbourg Court. The fifth section of the court decided to join the Springer case to the case Van Hanover and Germany 2, another famous case actually, and to relinquish jurisdiction in favor of the Grand Chamber in 2010. The parties did not object. The Grand Chamber disjoined later the case from the Hanover 2 case, from the Springer case, and stated as reasons the nature of the facts and the substantive issues raised in these cases. And this kind of strange history means that we don't have a decision of a section before the Grand Chamber decision. So immediately it comes to the Grand Chamber decision. Now, the Grand Chamber of the European Court of the European Court of Human Rights, in Strasbourg, the Grand Chamber quickly declares the application admissible. Not many problems here. As usual, the evaluation of the merits commences with the submissions of the parties. Hardly surprising, the German government emphasized the margin of appreciation that the member states enjoy. These submissions mention valuable aspects of the nature of limited review. I will come back to that. Nevertheless, they found little, if any, reflection in the reasoning of the Grand Chamber, these margin of appreciation things. Springer challenged the evaluation of certain factors in the balancing undertaken by the Landgericht and Oberlandesgericht, the first two German courts. In some of the third-party interventions, there is emphasis on a wide margin of appreciation for the member states. Good. Now, there is no doubt that there was an interference with Springer's freedom of expression, and that owing to Germany's domestic statutory law, this interference, the sanction, is formally prescribed by law. The only issue is proportionality, or in the wording of the convention, actually in the interpretation of the court of the wording of the convention, I should say, whether the interference is, quote, necessary in a democratic society. The key phrase for proportionality. The assessment commences with the usual phrases stressing the importance of freedom of expression. The court highlights the functional importance of free expression for a democratic society. Unlike other freedoms, freedom of expression is not merely undergirded by the individual's interest to express oneself. It is also undergirded by a weighty collective good, namely the functioning of a deliberative democratic debate. This is to say that the individual right is supported by a weighty collective good, more supported in the case of genuine political debate, less in an entertainment context or purely commercial speech. This is not politically really relevant. This functional approach is mentioned by the Grand Chamber as the justification of the press for reporting all matters of public interest. This is, however, only convincing if the interpretation of this expression has a democratic functional overtone, not some celebrity stuff, who has cheated on whom thing in yellow press. This is not politically really important. The court then goes on to characterize the right to respect for private life according to Article 8 ECHR as a potential limiting reason. This is standard doctrine. In what follows, the court mentions the margin of appreciation that member states enjoy in the framework of European supervision. Indeed, the task of the court is limited review of the decision of German courts. What, however, is precisely limited review? A case such as Springer and Germany is typically subject to decisions by up to no fewer than 6 instances with different panels of judges. It is not the case that every higher instance undertakes strict review of the immediately preceding decision. The Landgericht, first instance, decides the case on the basis of German statutory law, interpreted against the backdrop of the German Constitution and the European Convention of Human Rights. The Oberlandesgericht, second instance, undertakes strict review of the decision of the Landgericht. The Bundesgerichtshof, Federal Court of Justice, third instance, undertakes only review on points of law, not facts, and this only under certain procedural and substantive circumstances. This review is actually limited in several respects, but in a different sense of limited review of balancing decisions, which will be explained in what follows. What is more, the Bundesverfassungsgericht, fourth instance, reviews only the constitutionality of decisions of German ordinary courts, Fachgerichte, not whether statutory law as such was interpreted correctly. Something different. The review of the balancing of constitutional rights undertaken by ordinary courts is only subject to limited review. Finally, a section of the Strasbourg Court, fifth instance, and or the Grand Chamber, if it comes to that, sixth instance, undertakes limited review of the final decision of the courts of the member states. It is also worth mentioning that the legal instruments for the protection of human rights applied by these instances, the rights of the German Constitution and Convention rights, may be different to some extent, different wording, different limiting phrases and so on. But every legal instrument itself and every legal decision applying such instrument raises the claim to moral correctness, namely the claim that the respective legal decision counts as an expression of human rights as moral rights. Owing to differences in space and time, the positive morality, the factual interpretations of what human rights as moral rights require in such a case at hand, this may differ more or less. Of course, there's disagreement. Human rights as moral rights are, however, the vanishing point, Fluchtpunkt, behind all legal judgments on national or international fundamental rights. In short, limited review is a phenomenon that arises owing to epistemic uncertainty, uncertainty of our knowledge on what human rights require and to the division of labor in authoritative structures in the national and international legal system. The European Court of Human Rights actually is aware of this problem and refers to that issue as the problem of the fourth instance. In the German case, it's the fifth or sixth, but in some other member states, it's just three, and then fourth instance is Strasbourg. So being at the top only empowered to undertake limited review. Good. Coming back to the case at hand. Before one analyzes the justification given by the Grand Chamber in greater detail, it is well to have a look at the dissenting opinion of 5 judges of the Grand Chamber. The core criticism in the dissenting opinion is that the Grand Chamber misjudged the margin of appreciation and took the role of national courts. The core sentence in this dissent reads, quote, "In order to exercise this court's powers of review without becoming a fourth instance, our task in guaranteeing respect for convention rights in this type of case is essentially to verify whether the domestic courts have duly balanced the conflicting rights and have taken into account the relevant criteria established in our case law without any manifest error or omission of any important factor." It's an important phrase. The dissenting vote then goes on to explain that the decisions of the German courts met this standard. So the dissenting opinion says Germany was okay with what happened, was okay. The nature of limited review is reflected in the wording of the court's reasoning, where one reads, this is now the majority opinion, the court's task is not to take the place of national courts. The standard applied here seems to be, however, far stricter, requiring not merely application of the arguments without manifest error or omission of any important factor, as the dissenting vote states, but the Grand Chamber majority says application in conformity with the criteria laid down in the court's case law. And this latter phrase might indicate strict review rather than limited review. What then is precisely the difference between strict review and limited review? In the case of strict review, a review organ applies the substantive law itself and then simply compares as to whether the decision to be reviewed arrives at the same result. So they say, what would I do? Would I do the same? Then it's fine. If not, not fine. So if yes, the decision to be reviewed is upheld. If not, the decision to be reviewed is rescinded and replaced by the decision that of the review organ, the higher court, with a different result. This is fundamentally different in limited review. The decision to be reviewed in a limited fashion can involve balancing, subsumption, or both. This is now fundamental doctrine of constitutional rights. Since in Springer and Germany, the review of proportionality judgment takes center stage, I shall focus on balancing. But the same could be done with subsumption. A paradigmatic level of intensity of review in limited review is plausibility review. In German, Vertretbarkeitskontrolle. Plausibility review means that the review organ refrains from imposing the result that itself regards to be the correct balancing of the competing rights. Rather, it merely asks as to whether the decision to be reviewed arrives at a plausible result. Not correct, plausible. This is less. Unlike in the case of strict review, there are not only 2 outcomes, correct result, wrong result. There are, however, 3 possible outcomes. Substantively fully correct result, not substantively fully correct, but plausible, and neither fully substantively correct nor plausible. In plausibility review, the decision to be reviewed passes review if it is substantively fully correct or at least plausible. To put a sharp edge on it, the decision to be reviewed can be substantively wrong and at the same time correct from the point of view of plausibility review. If the court says, okay, I would do something different, but this is okay. It's not correct, but okay. Yeah. This is to say that two different levels of correctness can be distinguished. This is now a bit theoretical, but essentially it says the same. Purely substantive correctness on one hand, and correctness based on, I would do the same, and correctness based on balancing substantive rights and goods under epistemic certainty in a situation in which there are reasons to give relative deference to a preceding decision. To say, okay, even though one would do something different. This is the point. Now, the potential difference between these two levels, fully correct and not fully correct, but okay, is the more pronounced, the more limited review that is undertaken. It's actually technically a sliding scale. It's a sliding scale, I would argue. And plausibility and arbitrariness are kind of two simplifications of that. It's a sliding scale. It is greater, for example, if one asks whether a decision to be reviewed is not arbitrary, and the phrase without the dissenting vote phrase, without any manifest error or omission of any important factor, and the dissenting vote goes actually in this direction, the non-arbitrariness review, even weaker than plausibility review. And the review, this is the upshot, is the more limited, the greater the epistemic uncertainty. Good. Now, if this is true, I think it is. There are two different strategies for the review organ, for the court, for presenting plausibility review. The first strategy consists in, first, balancing all competing substantive rights, establishing what I called substantive correctness, and then, second, determining in the light of this result whether the decision to be reviewed departs from that result only to such an extent that it can be regarded as plausible. So, finding out what is the fully correct answer and then kind of thinking about the difference of what happened to that. And this is, I call this the open strategy. The court, so to speak, does this all out in open reasoning. The second strategy, which I think courts like much more, the second strategy is the hidden strategy. And this is to presenting the comprehensive assessment by immediately asking whether a decision to be reviewed is plausible, without revealing whether the review organ, if they were to decide the substantive merits of the case, which they are not, but if they were, would arrive at a different conclusion. And I, as I said, call this the hidden strategy. It might seem to be an advantage of this hidden strategy is that it avoids the confusion of laypersons that may arise with an eye to two different levels of correctness, as explained above. How can one admit that a decision to be reviewed is substantively wrong, but passes the relevant standard of review? This sounds a bit suspicious for laypersons. To say, I'm confused. Now, is it right or wrong? I don't know what you are saying. Lay people say. Well, they say this often anyway, but this is another issue. There can, however, be little doubt that one can evaluate the plausibility of a decision to be reviewed only after balancing the substantive merits from one's own point of view, I think. Even if the hidden strategy is chosen for presenting the issue in writing, in performing plausibility review, the review organ has to go at least implicitly through these steps. Balancing the substantive merits of the case, compare this with the result of the decision to be reviewed, and in cases in which the two results differ, if not, there's no problem, obviously. If they differ, evaluate whether considering to which extent the difference between the two results counts as plausible or not. The advantage of the open strategy, I would actually recommend the open strategy, is that it presents a much clearer justification in terms of legal argumentation and, of course, a much clearer precedent for future cases. Because after a given case, we are always before the next case. So we have to think about the contribution of a justification in a case to future cases and legal certainty for those who are the addressees of the law. Good. This is to say that it is perfectly legitimate if limited review, if the review organ evaluates the substantive merits and balancing of the competing rights from their own point of view. This is perfectly fine. It needs, however, after that, to be placed in perspective, considering the epistemic uncertainty and the weight of reasons to defer to a preceding decision. There are different reasons. Good. The Grand Chamber, coming back to the case, acknowledges at the outset that it is not supposed to take the place of the national courts. Great. This sounds good. Promising, from my point of view. Then it concretizes the standard of review in the following key sentence. I quote the court here again, where the balancing exercise between those two rights has been undertaken by the national authorities in conformity with the criteria laid down in the court's case law. The court would require strong reasons to substitute its view for that of domestic courts. Now, that, as I will explain now, sounds less promising to me. There are actually problems here. The first issue is that this requires a certain process. Balancing has been undertaken, that the court has gone through a procedure of doing that. It requires a certain process rather than merely a certain result. And the dissenting vote actually does not dissent on this. It goes very much in the same direction, that the process is required. This is what we call in German Vorgangskontrolle, that actually it is just reviewed whether something has taken place as a historic act, so to speak, in the past. This is, however, less clear in the context of a review of parliamentary statutes. If a directly democratically legitimated parliament enacts a certain statute that objectively represents a plausible compromise between the two competing convention rights, would the Grand Chamber require that Parliament, in the case of German, that the German Parliament go through the process of using the criteria from the court's case law for arriving at the statute? And if that process, that the German Parliament in its deliberations does not refer to the Strasbourg criteria, if the process did not take place, is this procedural defect alone sufficient to pronounce a violation of the convention? So would they say, okay, your result is perfectly fine, but your process was flawed. So you're in violation of a convention right. And what they say implies that they would have to do that. Or would actually a correct result be sufficient, independent from the process it was arrived at? This is something completely different. And there's no clarity on that. Now, the second issue is that the Grand Chamber seems to insist on the court's very own set of criteria for the balancing. To be sure, there may be reasonable disagreement as to what the relevant set of balancing criteria is. The dissenting opinion is far more tolerant in this respect, for it requires, first, that the balancing be undertaken without an omission of any important factor, indicating that some of the court's criteria may be, in a concrete case, less important. So leave them out. That's fine. And second, merely the application of the criteria without manifest error, rather